Chancery Court of Dickson County is now in session. The Honorable Judge David Wolf presiding. All you have in business with this court, draw 9, you shall be heard. God bless the United States, the state in this court. You may be seated.
All right, good morning. We'll start with a call on the docket.
Good morning, Your Honor.
Good morning.
That's my adoption uncontested, but I will warn you, we have a lot of support today.
We have a big courtroom. So.
We have a big courtroom. Hopefully people will come.
Okay. Well, if you're ready to take it up, I'm ready to hear it. So.
Yes, sir. I'll go get them.
All right. Okay, everybody that wants to be involved, come right up here.
We're going to have you guys stand right here.
Leonard, if the adoptive parents need to stand in front of the microphone.
Okay, we all will stand back here. How about that? Okay.
Everybody that wants to be a part of this, if you're here for this adoption, come on up. Keep coming. Move.
I'm telling you, it's a lot. I think we filled the parking lot, or 2 or 3. And Lisa, where's Lisa? Come on, you come over here. This is one of the caseworkers that did their home study. So I want you to testify, okay? And then we've got the girls. You can stand right here if you don't mind. Big sisters, which are important. Okay, and do you mind if,
I don't
take
mind.
some pictures?
For an adoption, anything you all want to do is fine with me. This is your courtroom.
Okay.
You just get, all these people need to come right on up here. This is a once-in-a-lifetime event for these folks, so everybody that wants to be involved in it, come right up here. So.
Okay. We still have people coming in.
Officer, that chair, give this young lady that's having the problem with standing, give her that chair and let her have a seat. So. I've had foot surgery before, so I know what it's like to have to try to maneuver when you have a bad foot. Is there anybody else that's out there that needs to come up? All right, I want everybody that's out, I'm going to put everybody under oath, and I'm going to ask you all some personal questions. Is that all right with you? Actually, those people who are going to be testifying for this adoption need to raise your right hand. Let the clerk place you under oath. All right, thank you. You may proceed.
Thank you, Your Honor. As you know, this is Judge Wolf. They actually requested you. Thank you for being here today. Option.
You're welcome.
This is Colin and Bethany James. Do you want to introduce yourself and then introduce your, okay. These are the big sisters, biggest sister. Do you want to introduce yourself and introduce your younger sister and your brother?
My name is May James. This is my sister Lucille.
Nice to meet you.
Nice to meet you too.
And this is
Judah.
And we're here for Judah.
It'll be the one time in your life that you're glad that you have to talk for your sister. So.
Public speaking is very important. You'll grow into it, I promise. Well, the James fabulous family, and we are here for the adoption of Judah. The James acquired custody of Judah from Miriam's promise, which is a licensed child. They accepted surrender of the birth mom and have supervised the placement. This is Lisa Mosley. She is with Adoption Assistance that actually did the home study, the 2 agencies here. And so we're glad that she's here. The case representative from Marion's Promise had surgery yesterday, so she could not be here. I do have the agency's consent, my fee affidavit, and my final adoption for your review.
All right, do you want to hand that to the bailiff?
If I didn't sign that order, let me know. We all got back from vacation yesterday. So, the birth mother executed a surrender, and her surrender under oath is unknown. We're asking the court to substituted service and declare him an
Well, let me let you know, I've reviewed your file before today, so I'm aware of the
good.
facts and
Okay.
circumstances, and I will waive any requirement of any additional service since the birth father is unknown and cannot be determined. All right?
And Judah's been in the home the requisite amount of time, as you know, the law is 3 months. All necessary documents have been filed with Your Honor, including the home study and post-placement.
And I have reviewed the home studies.
And with that, I'm going to ask James's a few questions.
That's fine. If you'll step around that corner a little bit so the microphone can pick you up a little better. So,
Here we go. I'm going to ask you folks a few questions if you just want to answer appropriately to the judge. Could you please state your full names? We'll start with Mama.
Bethany Bradbury James.
Colin Phillip James.
Is everything in your petition for adoption true and correct?
Yes.
You've heard the procedural history I've given to the court. Is that true and correct? And can you confirm to the court that birth father is unknown and you're asking that he be declared an unnecessary party? Are you guys financially able to provide for Mr. Judah?
Yes.
Do you understand that after today, under the laws of Tennessee, that you'll be able to inherit from him, and he'll be able to inherit from you and your daughters as if he were born to you? I should say your family too. And do you further understand that under Tennessee law, that you'll be responsible for him as you have been and as you are with the girls, financially, emotionally, spiritually, medically, and otherwise, until he turns 18 or until he graduates with his regular high school class, whichever occurs last?
Yes.
And I'm going to cry. My son just is about to turn 18 and just graduated from high school. Oh, my gosh. That really hits you hard sometimes. Of course, those are your minimum requirements. All the judge will make you do. But I'm sure it'll extend much, much further than that. And in the adoption world, we say forever and ever, amen. And then, Lisa, could you please state your name? Lisa Moses. And you are the case representative for Miriam, adoption assistant.
I did.
And do you have anything else to add to the court?
Just a wonderful.
It is. And Your Honor, I was very remiss in not introducing family and friends, and that's where we're going to leave it behind me. But those are all the formal questions I have, Your Honor. I'm going to leave it
all
up
right,
to
Mr.
you.
and Ms. James, my job is to make sure that you understand the significance of today and what you're actually assuming by going through this process. Right now, you're both the custodians of the child, and the child has been placed with you. But if I grant this adoption, he becomes your child, the same as if he was your biological child. That means that all rights and duties and responsibilities of a biological parent attach to Judah and to you too, and they will be your son, the same as if you had given birth to him. You understand that? And that also means if, God forbid, something happened between the two of you and you went through a divorce proceeding, you would both have equal standing regarding custody, support, and so forth under the law. Now, you have two beautiful girls, and now you have a young boy that you're wanting me to adopt. He's cute, lovable right now. Someday he's going to be a teenage boy.
Yes, he is.
I'm not sure if you really understand that, and I'll tell you a story. I had my first son, and I was with a law partner who had two girls and a boy. And so when I had my son, I came back to work. He said, well, what'd she have? I said, he had a boy. He said, just put him in a sack, throw him in the river right now. He said, girls are the only way to go. So you've got two beautiful girls. They're going to help you with this young man as well. But you understand that this is one of those situations where he stays out and dents the car. When he's 16, you can't bring him back to me and say you've made a terrible mistake. So you both understand everything you're assuming and what you're asking me to do. Then I've reviewed your file. Everything is in order, and I will be happy to grant your adoption. So.
Thank you. Again, Your Honor, you did say the courtroom is ours, so I'm going to assume that you are okay if we stand in front of you and have a picture with you?
Sure.
Okay. Why don't we just have the five immediate family, and then we'll do our best to
Well, if
flip
we're going to do the
around.
immediate family, they can come up here. They can come on up,
Oh, that side.
come around here if
No.
y'all want to. and
Yes.
We'll do it up here.
Just the five of them, first of all, and then we're going to have the family go up with them. But I don't mind. Hey, Lisa, will you grab the
could bring the big chair here, if you want to sit in the big chair. So we all
Guess it
gather.
really doesn't matter, the white one's just a small one. I promise they're in there.
Good to see you.
18 in a week. Okay.
Oh, this is beautiful. Hey, Judah. Yo, make him look. I know you know how to do that. Hey. Judah. There we go. Okay. Now, everyone that's here, if you will flip around the best you can in front of the judge.
One individual gavel, so.
No, just stand right here in front. Don't be shy. Do the best we can. You guys, no. If you're here, you're going in.
Come back down or stay up here? Y'all want to stay up here? Might be better for staying up here.
All right. No, the little ones need to come over here. All right. Everyone needs to take one step in. Act like you like each other. One more step in. Seriously? Come on. No, you can stay there. You're cute. Okay, perfect. Burger. Buddha. Okay.
No problem. I knew your name, and I thought you were probably. I'll have to let them know.
I'm gonna wrap the file. Hopefully, thank you. Hopefully, I took at least one picture. I don't responsible for that back picture. That picture.
Thank you so much.
I'm Lisa.
Yep, hold on just a second.
He's a great guy. He's a good one.
And there you go. Thank you. You're welcome. And with that, we'll just adjourn for the day on a high note. Good morning.
Morning, Your Honor.
We are overrun with children today, so
We do. We're just,
both of you raise your right hand. Let's place you on the road. My understanding is that you have, as the natural biological parents of your child, that you are asking to change your minor child's name. Is that correct?
that's correct, Your
All
Honor.
right, I know you've set this out in your petition, but I'm required by law to ask it on the record. Are you asking to change his name to avoid criminal prosecution?
No, sir.
Are you asking to change his name to avoid any sort of custody order?
Sir.
Are you asking to change his name to avoid any sort of creditors or claims that might be asserted?
No, sir.
If I understand, you just want to add let's see, you're adding you're adding David to your child's name.
That's correct, sir.
Of course, I would expect that I would be willing to approve adding David to your child's name, so why don't we do that? So Jehu, is it Jehu?
Jehu.
Jehu David Bennett Poole will be his name here. All right? Hi there. Are you going to go by Jehu or David? Which one do you want to approve? Jehu? David's a good name. You might want to think about using that one sometime, so. All right, I'm happy to grant the adoption. I'm sorry, the name change. I'm still in the part. Do you have an order?
Yes, sir. I have the two petition documents underneath.
Hand this to that young man. You can have your own little gavel, you just can't use it on your sibling there, so. I'm going to ask you, both of you, Mr. Poole and Ms. Bennett, to sign your signature on this behalf. You've got your name printed, but I want you to go ahead and sign that as well, if you don't mind, please, just to signify that you were here and had this done, so. I'm going to hand you back the copies that you had, because we have them obviously in the file, and you might want to hold on to those copies that are marked file.
Yes, sir.
I've signed your order and changed your son's name.
Thank
Okay,
you.
thank you.
Thank you, Your Honor. Thank you, Your Honor.
Thank you.
Okay.
28th of,
August, this term vote's next, but I.
all right.
We have, and we've agreed that if for some reason up that we can agree to that.
Autumn has a soccer match.
Oh, that's right, yeah.
We still
Okay.
don't have her soccer schedule.
Okay. Ms. Roberts, Mr. Daniel, motion.
Reset that, I'm sorry, we passed an order.
Is that what I just signed?
It's the Humphreys.
August 26th.
Yes, Your Honor, we did that.
The other attorney filed several things this morning. Up for discussion and see if we can work through issues.
All right, I'll put it on the second call.
Morning, Judge.
Good morning.
Say hello.
Thank you. Good morning.
I actually represent Ms. Nelson. I know Mr. Odell's marked on there, but Ms. Nelson is here. It looks like Mr. Nelson has also appeared.
Samantha Nelson and Jonathan Nelson.
Judge, this is our motion for default. Mr. Nelson has received criminal charges both prior to and following being served with this, and he's retained counsel for that. He has not made any efforts to contact me, or I've not heard from any attorney on his behalf.
Mr. Nelson, I want to make sure you understand that you were served with process in this case back, appears to be on April the 30th of 2026. The summons that was served upon you states essentially the following, that you have to file your answer within 30 days of the date you were served with the clerk and serve a copy upon your wife's lawyer, and that if you fail to do so, a default judgment can be entered against you, and therefore you haven't appeared in this case. In other words, as far as I'm concerned right now, according to this file, you've never even appeared, even though you're here physically. You haven't appeared in the case by filing any court of documentation. The reason that's important is you have to contest the issues that are contained within your wife's complaint for divorce. Are you intending to hire a lawyer? Well, you understand you've not filed an answer and that she's entitled to a judgment by default on the grounds, at least, it would still require a hearing as to whether or not or how the divorce is going to be put down. But the question of whether or not your wife is entitled to a divorce from you would be resolved by this default judgment. You understand that? All right, your default judgment is granted on the grounds for divorce, and we will set it for final hearing on all the remaining issues. Are there children involved?
There are children involved, Your Honor. It looks like there's a July 29th court date. I don't know if that's still available. Is there not one? Sounds great.
What that means is on July 30th, you're going to appear in front of a different judge, and that judge is going to make the rulings regarding the custody, division of assets, and so forth. You need to be prepared to either represent yourself or retain an attorney, and I understand it's not inexpensive to do that. But if you appear and you're representing yourself, that judge is going to hold you to the same standard that a lawyer would be. In other words, the rules of evidence, the rules of procedure will apply to you the same as if you had a lawyer. So my recommendation is if you're going to have to represent yourself, you might kind of brush up on what the law is regarding a divorce and custody of the child, or you can talk with your wife's attorney, and Ms. Lowe can explain to you what they're asking or what they're going to be asking for at the final hearing, and see whether or not you all can agree to negotiate an agreement. So, who is the judge on the 30th? All right. I've signed the order that grants the default judgment and sets the remaining issues for the 30th of July.
Thank you, Your Honor.
Thank you. All right, I've been asked to make an announcement. If there is anyone here for the case of Wilhelm versus Wilhelm, that matter is being heard in courtroom 3 downstairs. So if you're here for Wilhelm versus Wilhelm, you need to go downstairs. All right, call the next case. All right, I'll show that there was a motion for default judgment, but an answer has been filed. Are you Mr. Pierce?
No, I'm Mr. Butts, the plaintiff.
Oh, you are. I'm sorry.
She has filed an answer last week.
An answer and counterclaim has been filed as of June 12th on Friday of last week, so I am not going to grant the motion for default judgment since an answer has been filed. And he'll have 30 days to file, Mr. Butts will have 30 days to file the answer to the counterclaim that you filed.
Your Honor, I already filed the answers this morning before court.
All right.
I only have a amended complaint to file later today.
All right, you file your amended complaint, serve that on the attorney for the defendant in the case, and then we can go from there. So. All right, thank you.
Thank you.
Judge, this was my motion for default. In the interim, we received a notice from Ms. Gross requesting additional time, as is the court's general.
Well, the court doesn't, I mean, by law, the court doesn't favor default judgments. And, you know, courts are supposed to hear the matters on the merits rather than on default. So we'll grant Mr. Gross, how much time are you?
Ms. Gross, she
Ms.
is
Gross,
not
I'm
my
sorry.
client. 30 days is fine, and I went ahead and kept the motion on the docket today because I'm gonna talk to her for a few minutes about potentially the two of them going to mediation. They're close, and my client's willing to pay for that.
Ms. Gross, I'm going to grant you 30 days to file an answer. You can either hire a lawyer to represent you and have them file your answer, or you can file an answer of your own. If you file an answer, then you have to take that complaint that was filed, and you have to go through every line of that complaint, every paragraph rather, and you either admit what is stated in that complaint, or you deny it if you don't think it's true. And then you file that answer. If you want to file a counterclaim, you can do that, but I'm not giving you advice on that, but you just need to file an answer within 30 days if you're not able to resolve this thing, okay? All right, should be granted 30 days.
Thank you, Judge, and if for some reason we set it for mediation, I'll extend that by way of an
All
agreed
right,
order.
that'll be fine. Thank you. All right, after all of the machinations and contortions that we went through in this case, it's my understanding from the review of the file and the information filed that the lady was not the child of one of the uncles or whatever it is. She's not related to the family.
So Judge, I think if I can address that just briefly. We're here today on 3 motions filed by Mr. Vandervoort. I'm standing in for him. One of those was to address that very issue, Judge. Mr. Knowles has filed a response today in which he is challenging that.
Challenging the
Number one, the DNA results that they've provided, there's no chain of custody, there's no affidavit from a doctor, there's no explanation of what this new paternity test is. Dr. Blue, who you ordered to do it, is not the doctor who conducted it. There's so many issues with it that I believe it's hearsay and not admissible. And there's a whole new issue that has arisen since our last court proceeding, is at the auction of the personal property, it was discovered the family Bible was there. And the family Bible indicates that my client's mother, along with Charlie Mike, were married 4 months prior to her birth, along with other typewritten documents that evidence the same.
All right, so you represent the lady out in Washington State.
Yes, Judge.
And you're saying that these new developments basically may go counter to any sort of absolute determination of this DNA testing that wasn't done according to the court order?
Yes, Your Honor, if the court
Or
determines
was it done according to the
it's clear
court
and
order?
convincing evidence that they were married prior to her birth based on these families.
All right, so do we need to have a hearing or we just do an argument?
We are, Your Honor, the scenario being that I've had Bible and the notation that I have. Again, we're going back and doing the archaic. If you were married at the time of birth. The husband, biology had nothing to do.
Do we have a certificate of marriage from whatever state
Well,
they
we
had?
have a birth certificate with
The father.
uncle's name on it. But again, I'm a bystander. But again, it's a situation where we're gonna have that hearing. Necessarily, the law at the time, biology and DNA had not developed as it was, so then we have whether or not the law or biology, if they can prove that they were married. The birth
Well, are we
certificate-
prepared to do that hearing today?
Judge, if I could address that, I think based on the response that Mr. Knowles has filed, Mr. Vandervoort's going to need some time to take a look at that to come back and address some of these issues. So what we're going to ask is that these, and the other two motions are also related to this. So we're going to ask that all three motions be reset to the court's September date.
All right, you have a date in September you want to have it heard?
I don't.
Well, I gave 6 days in September to, that's a Friday. That's a good.
I don't have Mr. Vandervoort's calendar, but I'll speak for him. And if we need to.
Anytime that I see Ms. Roberts smiling the way she's smiling about a case, I dread what's going to happen when we
Right,
actually
Judge.
get into the case.
September 4th is a good day for me, Your Honor.
All right, so that we're clear, these motions, the three motions that were filed, which are the motion to confirm and the determination of the DNA testing, and the motion for attorney's fees in this case and the next case, filed by Mr. Vandervoort, are all going to be reset for the September 4th date. And on that date, we're going to have a hearing with evidence presented to the court for me to determine whether or not this lady is or is not the heir of or a legitimate heir. And that will be any evidence regarding a family Bible that's been discovered, if I understand correctly.
Which is lodged with the court.
The family Bible is lodged with the court? Okay. I wasn't sure if it was just a photocopy of the page or it's the actual Bible. I may need it to decide, to decide this case more than just the notations on it, so.
Your Honor may have stated this, but that hearing will also include my motion to dismiss their claim, attempting to disestablish Ms. Rundle. You know, the current law is they don't have standing to challenge Ms. Rundle as an heir.
All right.
So I think that's the first hurdle. My motion. Their heirs.
Well, we've got 4 good lawyers standing in front of me. I want you to draw an order that reflects what we're doing on the September 4th date in clear and concise language so that when in 3-4 months, when I pick up the file, 3 months, I guess it is, when I pick up the file to refresh my memory and look at it again, I want to make sure I know what we're doing. So.
A ruling on whether or not the party all related to it, and whether or not.
I would expect that this is going to take the majority of the day, so I would not want to set another lengthy. I'm not giving you another day. You are not the only court I have to deal with, so.
Judge, Mr. Vandervoort left me a very simple and straightforward matter to handle today, and I have failed, so.
Except that
We'll be
Mr.
back.
Vandervoort scheduled it on the back.
Right.
We'll take judicial notice.
Well, you know, if you remember Ship Williams, he came in front of Judge Birch back in Chambers one day years ago at the old courthouse, and Judge Birch had some loud, garish outfit on, so Ship just made fun of him left and right, as he was wont to do. And Judge Birch finally said, "Mr. Williams, what do you have today?" He says, "You can't touch me, Judge. I got an uncontested divorce." So Judge Birch took that file and went through it and found some technicality and dismissed the action because of the fact that he hadn't done it correctly. So don't tempt fate.
That's right, right. Correct. Thank you, Your Honor.
All right, September 4th.
Jack Johnson.
This was an exception filed to a claim, and I don't know if there's anyone here on behalf of the claimant.
Anyone here to represent the interest of First National Bank of Omaha? No one here to prosecute their claim, then your exception is granted.
Thank you, Judge.
If you'll have Mr. Vandervoort submit an order, please. This is here for a motion to adopt a temporary parenting plan.
It is, Your Honor. It's my understanding from Mr. Sartain that he has hired Mr. Sanders. Mr. Sanders is just getting back from vacation and unable to be here today. This is the second setting of this case. He was to be here with counsel today. Obviously, if he's hired counsel, then I don't know that a notice of appearance has been filed or anything like that.
Have you been able to contact Mr. Sanders' office?
I have not today.
Have you tried and not been able to, or you just haven't tried?
I have not tried this morning. I'll be happy to reach out and ask.
No offense to Mr. Sartain, but believe it or not, we do have people come in and obtain delays because they say they've hired someone when they actually haven't. So I'm gonna pass this case on the docket and allow Ms. Duke to contact Mr. Sanders' office to see if he confirms that he has been hired. It's unlike Mr. Sanders not to file a notice of appearance, especially if he knows that there's a motion pending. So we'll find out whether or not you have or have not hired the Mr. Sanders, and then we'll go from there.
Thank you, Judge.
Yes, and I had spoke with Mr. Sanders, so I had sent out my retainer on Friday, which I have a receipt as well from Mr. Sanders' office with me presently. And I spoke with Mr. Sanders yesterday, informing that he came back from vacation and he wouldn't be in his office until this morning. And I was going to ask him to change the venue from Dickson County to Hickman County because myself, my wife, and child all live in Hickman County.
That is an issue that you can't just appear in court and say, I want to change venue. You obviously have to establish what the correct venue is.
Yeah.
But we'll find out. Let's let Ms. Duke have an opportunity to contact her lawyer, and then we'll go from there.
Yes, Your Honor.
Judge, there is a preliminary matter on this involving Miss Leslie Cole, who is the attorney for Ashley Blair. We had issued subpoenas for the minor children that had made the disclosures that are the meat and substance of the petition that we filed. So I think we've got to hear that motion before we move forward with anything else.
All right. Good morning.
Cannon County Bar. I represent Miss Ashley Blair for the...
So that we're clear, the children that are being subpoenaed are not the children of Mr. and Miss Duffy together. They are Mr. Duffy's children by a prior relationship?
Yes.
Is that correct?
If you'll remember, Your Honor, you had our minor children
You're fine.
Our minor children attend visitation when those children were in Mr. Duffy's home for safety purposes. And now that they've made some disclosures, the children in this case are too young to come to court. So we ask that the older children come to testify as to the disclosures they made in the other case and in this case.
All right.
So this is my motion to quash those subpoenas for the older children. The children Ella, Parker, and Jackson. Ella is 12. Jackson and Parker are twins. They're 10. The motion is on two separate grounds, a procedural ground and then a substantive ground. The procedural ground is that the subpoenas are incorrect. The subpoenas that were served, they summon the children first to Miss Duke's office rather than to court, which is the 210 East College Street. The date listed is also 5/26. We were informed by email that the date had changed to yesterday, June 15th. And my office was not informed until June 3rd that today was actually the correct date. We have not been provided with a copy of any order showing that the subpoenas were continued or that today is actually the correct date that the subpoenas were continued to. So that's the procedural ground. On the substantive ground, these children are 10 and 12 years old, testifying against their own father, who they are exercising parenting time with. Mr. Duffy is still having significant parenting time with these children. The case that was filed in Wilson County was dismissed after a probable cause hearing, and he has significant unsupervised time with the older children. It would open them up to undue psychological and emotional harm for them to testify against their own father, who they're still seeing regularly, in a case that doesn't relate to them. That's just not fair to these children when it doesn't relate to them specifically. They haven't testified in any of their own cases relating to them directly. They did not appear in either the divorce case or the Wilson County dependency and neglect. They spoke to a guardian ad litem. We would ask that these subpoenas be quashed to protect the children and on the procedural grounds. If Your Honor believes that their information is absolutely required, we would ask that the least harmful method be used here and allow the children to speak to the guardian ad litem in this case so that they are not exposed further to the court process. Thank you.
Judge, respectfully, when the case was continued on the 26th, and it was due actually, I believe, to the mother's availability to have the children here, the order would have reflected, and it's just not been entered yet, the order would have reflected that the subpoenas remain in place. And everybody's here to testify. Your Honor, unlike the court in Wilson County, has an extended view of what has happened in this case all along. So Your Honor is well aware of the propensities of the father for erratic behavior, suicidal ideations, all of the things that the court has warned him against doing with these minor children. And Your Honor, I think, is probably much more aware than that Wilson County judge is of the dangers to these minor children. Your Honor has said it several times. This is the case where Your Honor witnessed him, and it just so happened we have had a video from the arcade at the bowling alley.
I remember the case.
Yeah. So these minor children made disclosures to their mother that were so significant, she reached out to Miss Duffy. But for the mother, Ashley Blair, we wouldn't have known any of this was going on. And now all of a sudden that something doesn't work out for her in Wilson County, she doesn't want to try to protect my client's children who are younger and cannot speak for themselves. I agree with Ms. Cole that the least harmful method for these children to testify and to bring these allegations to light is absolutely appropriate. I'm not looking to hurt minor children. I don't love the idea of them having to testify. But in this case, it's absolutely necessary. Otherwise, this man continues to hurt the minor children, telling them he's going to kill himself, carrying a gun around, continuing to drive a limo in the middle of the night with the minor children, leaving the minor children home alone by themselves. Big issues for the court.
Ms. Morris?
I represent Mr. Duffy in this action. As you know, our position is really to ask the court to dismiss this matter because most of the allegations that are before the court are based on these issues that have happened with Mr. Duffy and the older children. Meanwhile, the case in Wilson County has found no probable cause and has dismissed any action there. He's, again, as the attorney for Ms. Blair stated, he's having regular unsupervised visitation with those children. Those parties are very close to reaching a permanent parenting plan settlement. in that case, as well as establishing some kind of family therapy, which we agree would be appropriate. As this court has heard before, a lot of the issues that have happened with Mr. Duffy in the past do relate to some behavioral issues with Parker and his ability to manage that. And we admit that there have been issues with Mr. Duffy being able to manage Parker, and that is the bulk of what's going on here, the bulk of the incident that stemmed to all of these allegations. And he and Mr. Duffy and Miss Blair, who's Parker's mom, are really trying to work through those things. Again, the Wilson County Court has found no basis to suspend Mr. Duffy's parenting time of the older children. This case is really tailing onto that. And so our position is at this point, this case should be dismissed since it is entirely based on those issues in that Wilson County case. However, if the court does not dismiss it, I would also ask that the children be able to, rather than testify in court, speak through the guardian ad litem, Ms. Furlong Smith, and that she also be able to interview everyone else in this case. As the court probably recalls, she's already done home study visits of my client's home. There's been an expert evaluation. So we were really doing very well in this case. And again, this is an issue that I think is really tangential.
Ms. Furlong Smith, do you have anything you want to say?
I would be glad to talk with the children, the other children. I haven't. Of course, I'm not involved in the case, but I'd be glad to. I hate to just dismiss this outright until we get more.
Well, let me say this. We ain't in Wilson County. So the fact of the matter is, if in fact the Wilson County has been dismissed by juvenile court, it may be a different standard entirely than what is relevant as far as the evidence that this court will consider. But I will also say that the law is set up to try to protect young children, especially children who have been abused or have been subject to abuse, from having to come into court and testify if at all possible. That's why we have an exception to the hearsay rule that statements of children regarding abuse is an exception to the hearsay rule. So the children don't necessarily have to testify, but the statements they made could be brought in through another witness. Secondly, in criminal cases where individuals, where children are subject to sexual abuse or other abuse, the law is set up to allow them to be interviewed by the Child Advocacy Center, and a video of that interview is substituted for them having to actually go through the details of the case. So there's quite a few protections in the law intended to try to protect young children from having to come in and face having to testify. Understand, it is not particularly pleasant if anyone has ever had to testify. Sitting in the witness stand and being questioned and cross-examined is not a pleasant thing for anyone, and I fully understand that. So I'm quashing the subpoena, and I am ordering that instead that Ms. Furlong Smith is going to be allowed to speak with the children. And I am putting an order down here that Mr. Duffy and anyone else is prohibited from trying to influence these older children in any way or trying to give them a statement to make to the guardian ad litem. I want them to be unrehearsed. I want them to have a free and opportunity to speak with the children without any sort of threat of harm or having ramifications. In the interim period, obviously, I am not dismissing this action because, as I stated, I think there's a different standard for what was brought in Wilson County for what we're dealing with. And in the interim period, I don't know how long it's going to take you to do that, get that information made. My job is the best interest of the children. My only goal is to try to protect children and to make sure that they have a good relationship with both parents. I have a long history with this case, and we have gone round and round with it. And there have been some concerning issues with Mr. Duffy. I've heard multiple testimony I've heard testimony in the past where there was a physical abuse of the child, one of the children at the bowling alley. That was explained with more or less being angry by Mr. Duffy because the younger child had walked away from the older child and he was responsible for it. There was an instance where Mr. Duffy was working his job, driving late at night on an Uber or whatever it was that he was doing, and he had taken the children with him with a pistol to go help somebody recover some phone that had been left in a car. there are just a lot of concerning things that have happened in this case that they make me feel that it is important for the evidence that these older children may have can be brought in through the least harmful way to them possible. So I'm simply going to order that take place. I just need to know kind of how long we're talking about, Ms. Smith, because clearly this is a case that needs to be heard with some urgency so that if it's determined that there is no basis for those older children's statements, then this temporary restraining order needs to be vacated. If they substantiate it, then obviously we need to have a hearing to determine that.
Judge, would it be possible, since they're juvenile court records, we are not entitled to get those, would it be possible to make sure that the mother of those minor children produce the...
Well, she's not a party to this action. And she, other than coming in on a motion to quash the subpoena, I don't think I can order the mother of the older children, who is a non-party, to subpoena those records or to bring them in. You can request a judicial subpoena and see whether or not the juvenile court would honor that.
Is it, I'm not interested in necessarily having them. I wanted Ms. Smith to have access to them for purposes of questioning the minor children, because those statements were made under oath. So I don't know what purview this court would have to issue an order for her to be able to get those.
Well, the way of doing it would be to issue a subpoena to the juvenile court for those records to be brought to this court, and then I can put an order down today that Ms. Smith would have access to those records under seal. She would make an in-camera review of them. And again, my question is, if this order prevents Mr. Duffy from having contact with the children in this case, then there is an urgency to getting this resolved so that if it is found to be unsubstantiated, that we can allow Mr. Duffy to resume his contact with the minor children. And
I'll make myself available.
what time?
And Ms. Morris has said she will get Ms. Smith a copy of that petition just so she has it.
Whatever I can obtain from the Wilson County Court,
All right.
I will file and, or provide Ms. Smith.
I'm looking at the 22nd of July as being the next time that I could. That's not a date that I had normally given out for Chancery here. Ms. Morris. Ms. Smith.
Would the court want just
Well, if you're going to, here's the issue. Once you find out what these children say, then you got to determine how you're going to introduce that testimony of what those statements. And guardian ad litem's report, in my opinion, could not be substituted for a live witness who would testify that the children made. If it's traveling under an exception to the hearsay rule, you got to have a witness who's going to testify what the children said. So either Ms. Smith may have to testify in person if you're wanting to introduce it that way. And when are we thinking that you'll be able to talk with them, Ms. Smith? Okay. Let me take a recess. I'm going to check on my calendar to see the month of July. I'm supposed to be in Cheatham County, but there are a couple of days when I've got on my calendar to be back here. And I want to see if there's other, Wednesday is your day to be in juvenile court. All right, we'll take a short recess.
All rise. Court is now in recess.
arrived at is that we're going to put an order down that allows Ms. Smith to communicate with the minor children that Mr. Duffy has with his other ex in this case, that she will be able to try to talk to them, and that can be arranged in any kind of communication she has with Ms. Morris. May be able to get those records for her, or at least a copy of the petition that was filed in juvenile court, so that Ms. Smith can see what the allegations were. And it's my understanding she's going to try to do that on the 27th. Then beyond that, we're going to set a review on the 21st day of July at 1 o'clock here in this courtroom to, one way or the other, resolve this case or have a hearing on the issues. My understanding is the parties will continue to communicate regarding a resolution. So, thank you, Judge. All right, thank you. And then obviously I have quashed the subpoena, so.
I'll prepare an order.
But it does need to reflect that the quashing of the subpoena does not in any way, was not in any way intended to inhibit Ms. Smith from being able to speak with the children. I'm doing that instead of actually subpoenaing. All right, thank you. We're ready for the next case. Pardon me.
Good morning, Your Honor.
Good morning.
Judge, we were previously here on May 18th, and the court had put down an order. There were several motions on the court's docket that day. I'm not sure if the court recalls.
I do recall.
The court had put down an order saying the court would confer with Judge Wallace to see about taking over this case. I believe a motion prior to Mr. Thomas retaining me, and now Ms. Thomas has gotten new counsel, but there was a motion that occurred. I believe Judge Wallace heard it on temporary support. We had filed on behalf of Mr. Thomas a request for the court to review that, as he was not present when that was established. Beyond that, the court had ordered the parties comply and get the DNA testing done. That has been done. Mr. Thomas is indeed the father of these two minor children born during the pendency of the marriage. We also, the court had entered an order stating that this court had jurisdiction over those minor children in regard to the emergency motion for temporary custody that Mr. Thomas had filed due to the adoption with the newly born child. And I think the court ultimately left it at the court would confer with Chancellor Wallace about taking this matter over.
I did confer with Chancellor Wallace, and he has no problem with me hearing this case and doing whatever needs to be done. So.
Understood. And so I think where we're at, Judge, we have agreed, Mr. Kirby is now representing Mrs. Thomas. I believe he filed a notice of appearance in this matter last week. We have agreed I will give Mr. Kirby some time to get up to speed on the temporary support issues. I think we do have to address today the immediate motion, the emergency motion for return of the minor children. Mr. Kirby filed a response to that on Friday, citing the UCC JEA and how this court needed to reconsider its previous ruling on it having jurisdiction over that minor child. I don't know if the court wants to hear testimony on that today or just argument.
I'll hear whatever you want to hear. So.
And I really think factually it's undisputed. The child was born in West Virginia. There was an order of protection entered by the General Sessions Court here in Dickson that included one of the minor children on it. The baby Thomas had not yet been born. Mother relocated pursuant to an agreed order. That order of protection was appealed. The parties reserved that for a final hearing. The new minor child was born in West Virginia. Not entirely certain on the facts. The child at some point went from West Virginia, I believe the day she was born, and relocated to Colorado with pre-adoptive parents. I know it's mother's position that this court does not have jurisdiction under the UCC JEA to make an initial custody determination. However, father would aver that under 36-6216A2, this court does have jurisdiction to make that initial custody determination. I'm sure the court's familiar. It's kind of our argument that there is no home state of this child. home state is defined under the UCCJEA as a child that's living with a parent or a person acting as a parent. If the child is under the age of 6 months, it's the state in which the child's lived from birth with any of the persons mentioned. So that would be a parent or a person acting as a parent. Child's in Colorado, not with a parent and not with a person acting as a parent. The person acting as a parent is defined under that statute. It's our contention that the pre-adoptive parents in Colorado are not persons acting as a parent. So it's our contention Colorado is not the home state. That leaves West Virginia. There's no actions pending in West Virginia to our knowledge that we've been notified of. Also, mother under the UCCJEA has a continuing duty to supplement to this court in a divorce proceeding under the UCCJEA if anything is to change during the pendency, if the child is to relocate, knows of any proceeding that could affect the current proceeding. None of that was complied with here, Judge. We would aver mother has unclean hands. She's done this to try to gain an advantage in this divorce proceeding. I know that's more of an argument for father to make in Colorado if that court tries to exercise jurisdiction over this minor child. But we would assert under 36-6-216, A1 is not applicable, and therefore the court would have to go to A2, and we believe the court can exercise jurisdiction under A2 as a court of another state. Neither Colorado nor West Virginia has jurisdiction in this matter with respect to making the initial child custody determination. With that being said, if the court does conclude today that the court has jurisdiction, mother has filed documents in the Colorado court saying she surrenders her rights to this child. Mr. Thomas is the biological father. He wants to be the father. He's got stuff set up at his house to be the father. He couldn't communicate with Miss Thomas because of the order of protection. She relocated out of state. He couldn't be there during the birth of this child. That wasn't his own request. He was prevented by law from doing that. So it's not like we have a person that's just intentionally not being present in this child's life. He was prohibited by an order that he could not be there. So we are requesting that if the court determines that it has jurisdiction, that the court issue an order, a temporary emergency order, transferring custody of baby girl Thomas, who's located in Colorado, to Mr. Thomas, which also brings significant concerns to the party's other minor child that is in mom's care, custody, and control. She relocated and he's had no contact. When he finds out, and I think they're going to say there was some knowledge about him having knowledge of an adoption proceeding, he was not, they didn't communicate, there was an order of protection. He has serious concerns about this other child that's in mother's care. When you take one child and put her up for adoption and you surrender your rights, that he doesn't know where this other child's located. He doesn't know what's going on with this child. So he has significant concerns about the mother's fitness to care for the other child as well. So we're asking the court to, if the court determines it has jurisdiction in this matter, to make the initial custody determination to award him temporary immediate parenting time with these two minor children.
All right, you and Mr. Thomas have a seat over here at the table. Let me hear from Mr. Kirby, and then we'll start.
Judge.
Morning, Your Honor.
Good morning.
I'm coming into this court late in terms of this case, so I apologize about that, but I got hired and filed an agreed order for substitution late last week and filed a response to this motion. I was not present at what happened previously. I can't speak on that. But what I can say is this, that there was a statement made by opposing counsel in terms of Mr. Thomas wants to be a part of these children's lives. I think that would have been something that should have been considered prior to him domestically assaulting, sexually abusing, emotionally abusing the mother of these children at this point, to which he's not only pled guilty to the actual action, he's also pled guilty to a violation of the order of protection as well, and that's here. This is not something that is new for Mr. Thomas, as he has a background of domestic violence. He's actually currently pending a charge, I believe, in South Carolina for domestic violence against another individual. The allegations of which are that he threw items to include broken glass and attempted to strangle that individual. That is still currently pending. He is not a safe individual to have around. and he has made that clear. He has a history of drug use. We would say that he probably still is considering and taking those drugs. Obviously, with less than a week of me being on the case, I haven't been able to get everything together that needs to be together. I'm still getting the file together from not opposing counsel and previous counsel to come here before the court today. What we have here, though, is a question of jurisdiction where it is undenied that this child has never stepped foot in Tennessee, was not born in Tennessee, was
Let
born
me
in West
interrupt you and
Virginia.
ask this question. Are you aware how long this case has been pending?
Correct, yes.
It was filed October the 3rd of 2025, and your client has made an appearance and has filed pleadings in this court, submitted to this court's jurisdiction. Would you agree?
Not as it relates to this child, no.
Well, when you say not as it relates to this child, so you're saying that a person can have a divorce case pending in this court that concerns the custody of one of their children, and that if she flees the state and goes to another state, has a child out of wedlock or has the child there in that state, that somehow that robs this court of jurisdiction over the second child?
I don't think it robs the court of anything because I don't think the court ever had anything to be robbed of as it relates to the second child. She didn't flee the state. She was, by agreed order, allowed to leave the state because of the physical issues that had happened within the party's marriage at that point. Mr. Thomas doesn't know her address because that address is protected based on the physical issues that had happened within the party's marriage at this point. So she didn't flee in any way whatsoever.
Maybe that was a poor choice of words on my part.
I understand, Your Honor. As far as the jurisdiction of what we're looking here, I have no qualms that this court has personal jurisdiction over these two individuals as it relates to the divorce. I have no qualms that this court has subject matter jurisdiction as it relates to the divorce of these two parties. I have no qualms that this court has subject matter jurisdiction as it relates to the party's oldest child. I believe the name is Scarlett, if I remember correctly. I do have qualms that this court has jurisdiction related to the youngest child. And the reason being for that is that home state is defined as if a child is less than 6 months old, home state is defined as the state in which the child is born. West Virginia is the state in which the child is born. We don't get to A2, as was being argued by Mr. Bellamy, because we don't get past A1. West Virginia was the home state. We cannot confer subject matter jurisdiction to this court. These parties cannot agree to subject matter jurisdiction to this court. We have had many cases previously where we have a divorce going on in one state and we have to bifurcate it to the extent that custody has to be decided by a different state. I've had issues where custody is being decided by one state and it's bifurcated where child support is going to be decided by a different state. We have those issues pop up continuously, and this would be yet another issue of that point. When there is a question of UCCJA, I believe the next step, I think what the court is required to do, is to communicate with the judge of that other jurisdiction. We know what that other jurisdiction is. My understanding after talking to my client is that there was an ICPC between West Virginia and Colorado for the purposes of the adoption. I do not have a certified copy or a copy of that to hand to the court today. Again, I apologize, I'm coming into this late. I know that. I didn't file a motion to continue this because I know the court wanted to hear about this part of it. But I think Colorado has the open adoption right now. Mr. Thomas has representation in Colorado for that adoption at this point. He has every right to litigate that adoption in Colorado. And the adoption, as we all understand, would also be covered by the UCCJA as well. Child custody includes the idea of adoption litigation. I think it is most appropriate and the best next step, and I think what is actually considered and required by the UCCJA for this court to have an in-camera conference with the court that is doing the adoption litigation in Colorado and then discuss it from there. I don't think this court has the jurisdiction to take anything away from Colorado. I understand where the court's coming from, I do. But I don't think this court has the power to say, Colorado judge, you've accepted this. You've accepted these documents, you've accepted this litigation, but me sitting here in Tennessee, I'm going to take that away from you. Whatever happens after y'all's in-camera review, we can deal with that afterwards. But right now, I think that is the next step. As far as the argument of this child needs to be returned, or shouldn't say returned, this child needs to be given for the first time ever to Mr. Thomas, there's a couple things I would say about that. One, my client hasn't abandoned this child in the sense of just not having any communications with what's going on or not caring for the welfare of this child. In fact, she is sending breast milk to this child on a regular basis to the presumptive adoptive parents in Colorado.
Why is she giving this child up for adoption?
This was a child, this would have been 5 children in her home at this point. She has 4 other children, including the oldest child that's at issue here. This child there was some postpartum issues. This was something that was discussed, my client would say, prior to the order of protection being in place between these parties. It would be my client's statement that the father said on many occasions, or at least one occasion, I should say, that he would sign the adoption paperwork for that child if she signed the divorce paperwork. That's not where we're at, and that's not what's going on. Say that they never had any idea of adoption, that's false. They had talked about the adoption as it relates to this child. Was he given specific notice? I can't say that. I wasn't on this case when it happened. I'm going to defer to Mr. Bellamy saying that he got specific notice only when he got served. That's the best explanation I have as far as that's concerned, Your Honor, where they've had communications with it. This was a plan from the beginning. These were pre-adoptive parents that in Colorado that had been a part of this pregnancy throughout, is my understanding of this. This was always the plan, is my understanding. As far as taking that child and giving it to Mr. Thomas for the first time, a couple things that I want to say about that. One, we have an older child that's not even seeing this father right now because of all the protective issues that we have in place. 2, we still have pending criminal charges. 3, we still have an order of protection that's in place right now. 4, when we get to this point of looking at that, the consent that was there and submitted by my client, it actually states in there that were that adoption to not go through for some reason, whatever that reason might be, whether it's jurisdictional or otherwise, that child will return to my client's care and custody. That's what the consent states. If anything, if something happens with that adoption, the point emphasis would be that that child returns to my client based under the essential contract law that has been entered into between my client and these adoptive parents. The other part of this that I would say is that there's nothing going on with Scarlett. To say that there's an adoption proceeding there, that means that she's doing something with this older child is disingenuous at best. There's nothing that needs to be said about other litigation with Scarlett because there is none. If the court wants us to have a specific order stating that nothing will be done with that child, I have no objection to it because nothing's going to be done with that child. That child is with my client, that child's well taken care of, that child does not really even know father at this point based on everything that's been happening with this proceeding as far as the order of protection and protective orders that have been in place. Thank you, Your Honor.
This court is of the opinion that there is a fundamental difference in this case than in the normal UCJE Uniform Child Custody and Visitation Act cases. Number one, this case was filed in this court on October 3rd of 2025, and that was the complaint that was filed, so jurisdiction was invoked in this court. The court then conducted a hearing in front of Judge Larry Wallace in February of 2026 and entered an order regarding the custody, support, and so forth, which was again exercising the jurisdiction that this court had over these parties and the child that was born at that time. So what the argument that the defendant in this case, or actually it's the plaintiff in this case, actually the plaintiff was filed, a complaint was filed by Michael Thomas. The order that was drafted shows Rachel Thomas as the plaintiff, but I think that is incorrect. That may have been with the order of protection situation. In any event, the court entered an order that controlled the parties and ordered certain testing to be done for DNA. There was, I think there was an order for support and so forth that was entered in this court. So Ms. Thomas invoked the jurisdiction of this court to her benefit by obtaining an order of this court. Now she seeks to say that this court doesn't have jurisdiction over the child that was born simply because she relocated to another state. I am of the opinion that that does not prevent this court from having the opportunity to, or having jurisdiction to decide the custody of both children. To rule otherwise would encourage parties who are dissatisfied with the court's ruling on a custody case and they have a pregnancy involved, and they simply move to another state and thereby make the argument that this court is robbed of jurisdiction because that child was born in another state. I understand that where children are, the Uniform Act provides certain protections that if a child is living in another state and that state is asserted jurisdiction. But this court has already asserted jurisdiction over the parties and their older child. And this court, part of what this court will have to do, whether it's me or another judge, is to make a determination as to the custody of that oldest child. Part of that factor will be the behavior of the parents, all of those statutory factors, and the factor of whether or not these siblings are together or apart, and what was her reason in placing this child up for adoption and so forth. So I'm of the opinion that the jurisdiction of this court extends to this young child that was just born, and that the Uniform Child Custody and Jurisdiction and Enforcement Act does not prevent this court from having jurisdiction over that child simply because Ms. Thomas moved to the state of wherever she's located in West Virginia or wherever it is, and then placed the child up for adoption in Colorado. Colorado's only jurisdiction over the child is because the child was brought into that state for the purposes of an adoption. And if the adoption is not valid because there's been no surrender of that child by the father, then in my opinion, that court does not have proper jurisdiction under the Uniform Act either to do it. I think this court is the only court that logically would have the right to make those decisions. So I am of the opinion that this court, and do hereby hold that this court continues to have jurisdiction over the parties and the parties' minor children. The Colorado court obviously may take a different view, and there may be an extensive litigation involved in that. However, Mr. Thomas's request that this child be surrendered to him in view of all of the allegations that have occurred in this case is not something that the court will automatically take it upon myself to simply say, well, he's going to get custody of this child. He doesn't know the child, has never had any contact with the child, and the older child, there are certain protections in place because of the allegations of domestic assault and domestic violence. So it's this court's opinion, at least, that it is not an automatic thing that I can return this child to Mr. Thomas. The Colorado court's going to have to rule on whether or not they have jurisdiction. It'll be litigated there. I'm assuming that Ms. Thomas may choose to make an interlocutory appeal on my ruling regarding jurisdiction. If that's what she chooses to do, I would authorize that because I think it's a very unique legal question. In the meantime, Mr. Thomas's rights are protected against this court, at least under this court's order, from any surrender or any termination of his rights for failure to have a relationship with the child because he's attempting to do so, and this court is of the opinion that it would not constitute abandonment that would result in a termination. Then that brings us to what are we able to do at this point other than my ruling that we have jurisdiction. I think it's going to require, before I can do anything about that child, we need to see what Colorado is going to do regarding their I don't think West Virginia is really the issue. The child's not there. Being born there doesn't mean they have jurisdiction. So with that, Mr. Bellamy, you have anything you wish to add about today, other than the fact that I've reaffirmed my ruling? And we set this hearing to determine what the DNA tests were going to be. DNA shows he is the biological father. I'm therefore ruling that we do have jurisdiction over this child. If the defense wishes to seek an interlocutory appeal to a court of appeals for their interpretation, and I'm willing to do so, do you want to put on the record the circumstances of this so that there is a record made to take to the Court of Appeals? That would be the only thing I would offer.
Judge, just a few things if I could add briefly. The order of protection in this case, is the court saying that the order of protection extends to the newborn minor child?
I'm not saying that the order of protection extends to the newborn minor child. It extends to those people who are listed on the order of protection. The order of protection lists the mother and a stepdaughter, a stepson, and Scarlett Thomas, who is the child of these parties. It does not mention this unborn child. It was issued back in September of 2025, and therefore the child obviously she was pregnant with the child, and it could have mentioned that, but it did not. So I'm of the opinion it does not apply to that child, but asking me to order that the child be surrendered to Mr. Thomas in view of the allegations is what I'm simply saying. I'm not prepared to do that.
So I guess that would be my concern is when is the court going to be prepared to make that determination?
Well, I will give you an evidentiary hearing and you can make that argument, and then I will make a ruling. And if you want to do that today, we'll do that today. It's up to you.
If I may confer with my client just briefly, Judge.
Your Honor, as far as the evidentiary hearing, while he's conferring with his client on what he's been asking about that, I'm going to respectfully say that any evidentiary hearing on that topic, I would ask to be continued to another date for many reasons, one of which I just got on the case, as the court all knows, and we've already said on ad nauseum here this morning. Secondly, there are things that are related to what is happening with Mr. Thomas in his own personal life that I need to get proof of.
Mr. Bellamy, Mr. Kirby is right. He's new to the case, and I think under the circumstances, this is a unique situation. I'm of the opinion that I can give you July 22nd.
Give me one moment, Your Honor, let me check. I have a preview of the final hearing on July 22nd.
All right, well, my calendar in the month of July is full, but many of those are criminal trials. I've missed a call from General Lee Willoughby over in Cheatham County because I'd asked him about, are any of those, all of us who practice law know that just because it's on my calendar doesn't mean it's going to go. So bear with me and let me step off. I have a TBI agent that was supposed to be here. All right, he's here. And I need to see him about a judicial subpoena. Then I will check with Mr. Willoughby about that calendar, and then I'll let you know what we have available. My inclination is to set it for July, after you get Mr. Kirby an opportunity to be heard, or rather get prepared, and then we'll come back, so.
Understood. Thank you.
Thank you, Judge.
Sure. You want to make an announcement?
Pass the motion on Dunham to get the parties to mediation. And that's really all that the announcement is for today.
So, Ms. Bird, you act like you've got some other place to go.
No, I love being over here, Your Honor.
Well, all right, so you're just going to pass this? Is that
Yes,
correct?
Your Honor.
It's fine. We'll show it passed. All right, we'll stand in recess for a few minutes.
All right. Court is now in recess.
of July. After speaking with the district attorney, I have offered I can give you the 16th of July.
And depositions all day that day, Your Honor.
I can give, what about the 15th of July?
I have a dispositional hearing that day.
You have a hearing?
I do.
Did I suggest the 22nd of July already?
You did, and I had a hearing on that one.
What about the 29th of July?
29th would work for me.
I'll make it work, Your Honor.
All right, then we'll reset this matter for the 29th of July. And at that point, hopefully we may have some sort of ruling out of Colorado. Does anybody know what their status is regarding this situation?
I was gonna ask my client, but I don't see her on the WebEx anymore. I didn't want to step out and call her.
You may, she's exited the hearing, so.
Okay. I don't have one off the top of my head. I know that the last update that I got was that Mr. Thomas had hired counsel. I would assume there's a motion date, but I would need to check with the council in Colorado to see what their next
All
date
right.
is.
And Judge, that would be the update I've got to provide as well, but just some clarity for the record is that the court has stated that it's exercising jurisdiction in this matter over this minor child.
That is correct.
But is the court saying?
That's the day I'm going
further-
to, I'm sorry.
You're
Go
okay.
ahead.
Is the court saying any further determination regarding the minor child is dependent on the outcome in Colorado?
No, but I'm saying that it would be good to know what Colorado says, so,
Understood, but just for the record, this
I'm
court's
of the
exercising
opinion-
jurisdiction and it's not contingent on
I'm
Colorado's.
of the opinion that Colorado has, the right to decide whatever they want to decide. I'm going to rule that we have jurisdiction over this minor child. That doesn't mean your client's going to automatically get this
Certainly,
child.
certainly.
It will be a factor that this court has to determine, and I have to have an evidentiary hearing, and that's what this 29th is going to be about, is a custody hearing over this minor child that I've said we have custody over, jurisdiction over. And the defendant in the case, Ms. Thomas, will be able to present all of the evidence that they claim. All I've heard have been allegations. And that hearing will be for the evidence to be introduced that allows me to make a decision, and I will consider all of those factors set forth in that. In the interim period, obviously, Mr. Kirby may decide he wants to pursue an interlocutory appeal on the jurisdiction issue, and I'll leave that up to him to do that. So, but right now, I'm setting the Thomas versus Thomas on the custody issue over this minor child and the visitation with the other child as well. All of that will be subject to a hearing on the 29th, so both of you marshal your evidence, so. All right.
Understood.
Thank you, Judge.
Thank you very much, Your Honor.
Judge, on Sartain, I don't know if you're ready for me to let you know what Mr. got back to me. He said, yes, he dropped off payment and paperwork last week when I wasn't here, and I didn't realize until too late that a hearing was scheduled. He had just gotten back into town late last night.
All right. So you want to reset it for, how about the 29th of July?
That will work. And I'll do a notice resetting it, Judge.
So I don't hear any whining about you needing days in July, so.
I know, he's bending over backwards today.
Yeah, I think they appreciate it.
She's just tired of hearing us whine.
You what?
She's just tired of hearing us whine.
Yeah. All right. Let me give you back this Thomas file. Are you ready on the next one? That was Alan Hall's case, and I have not seen him. Okay. Yes.
Can you pass that one, Your Honor?
I will.
I'm waiting on a call from Neil Trice on that. Your Honor, in that case, if you would, I have my client here. Unusual situation, if we could approach. Mr. Kirby represents Mr. Robert Cameron McNeil, the plaintiff in this matter. I represent Ms. Shana Michelle McNeil. This case has been pending since 2024. Mr. McNeil lives out of state. Mrs. McNeil lives here with the minor children. We've gone back and forth, had some hearings in this matter and been to mediation. We proposed and sent a marital dissolution agreement to council. And then on Friday of last week, Mr. McNeil apparently signed that MDA in North Carolina that Mr. Kirby had forwarded to him and emailed him late on Friday the paperwork back. When Mr. Kirby got that, he forwarded it to me, I think on Monday morning, or late Friday afternoon, one of the times, and I contacted my client, thinking, and again, this is one of the age-related scenarios, because we were under the impression that Mr. McNeil had sent the paperwork to Mr. Kirby. So when we talked about that being sent, I anticipated that meant the originals. Apparently, my age showed on me, and he emailed via sent. So we don't have originals, but Mr. Kirby contacted his client yesterday when I advised him that this court requires a wet signature, not photocopies. So,
My client's informed me that he'll be sending those to me, but I have not received them as of yet. Once I have the originals with the wet signature on them, I can forward them to Ms. Roberts. The only thing I've done at this point is forward over the proof of what he has signed, which is a scanned copy of what is there.
and I have taken that scanned copy and had my client put her signature on that. So what I'm asking the court is, and that Mr. Kirby and I have signed a final decree. So what I'm asking the court to do is to allow me to supplement the MDA and the parenting plan, because today was the final hearing. I said it by motion, everybody had notice, everybody was supposed to be here. This transpired. I have my client here to testify that the marital dissolution agreement that we are presenting is fair and equitable. She's in agreement with it. It's in the best interest of the children. And I would just ask permission to substitute the originals so Your Honor can sign the final decree, and nobody can back. I just don't want anybody to
I will sign
back
the
out.
final decree, and what I would suggest you do is when you get the originals, just submit an amended final decree with the originals, and then that'll take care of it.
Yes, sir.
And for the record, I have no objections to what's being asked before.
Okay.
Do you want to put your client under oath to let her testify, or are you just going to rely upon the fact she
Well,
signed off on this?
I'm going to rely on the fact, because again, here's the scenario. Contractually, we put in there that they're divorced on the grounds of irreconcilable differences. So again, that being the scenario that I filed a motion to set, it is legally and correctly set today. And if by chance that Mr. McNeil tries to back out of it or does something, then again, I want this contractually bound, the court order. I want every avenue available to my client if that happens. I trust that it will not, but if it is, I want the sword of Damocles hanging over somebody's head.
I have signed this final decree of divorce. When you receive the originals with your client's original signature, then you can have Mrs. McNeil sign off on it and submit an amended final decree.
Yes, Your Honor. Thank you.
Thank you very much, Your Honor. That's all I have before the court this morning.
All right, Mr. Kirby, good to see you again.
Good to see you.
That just puts me in a situation that I still have to deal with. Thanks, appreciate it. Yeah, yes, Your Honor, that's a parental relocation motion that I filed.
If I may, I filed a response to that. There's also an adoption period plan. I've, in that response, raised some procedural objections to it being heard today, and I would like to be able, please the court, to take those up first before we hear the motion, if the court's inclined to let me do that.
All right, your objection is to the fact that your client received a text message rather than the notice that was required?
Well, there's a lot of dates involved too, as far as, this is kind of quick. There's about 16 days, I believe, involved in this. I've not had time to do any evidence. These are subject to an evidentiary hearing. I've got a lot there to argue as well. So there's a little more than just that.
All right, Ms. Roberts, he wants to argue his objection to the notice, I think.
Well, I think the scenario being is that you definitely need to rule whether or not we're having a full hearing on evidence on the relocation. I certainly agree that that's the proper way to go about it. But again, it's a scenario of where there's some legal things and the standing issue, and whether there's a parenting plan and whether there's an order granting a parenting plan and a residential schedule. Your Honor is going to have to consider all of those factors as to whether or not, when the parental relocation statute kicks in.
Do you want to have it heard today, or you want to move it to a day in July?
No, Your Honor, I want it heard today. My client has got a job. It needs to move, needs to relocate, so we're planning on going forward today. If Your Honor rules that it's not properly before the court, then we'll just have to deal with that. Because again, the issue being is there is no parenting plan. So effectively, Mr. Davis has had under the child support worksheet has been afforded 85 days. And so again, the scenario is it's well within my client's authority to, whether she can move or not is not an issue, but what his visitation is. And if he doesn't mind not seeing the child until we can come back for your September date, we're certainly fine with that.
I was talking about July, but I understand your position. All right. Mr. Hawley, I will hear your argument.
Thank you, Judge. And again, I had filed June 12th this objection to the petitioner's motion to allow the relocation. For the record, it appears that what we have done, the father came to me and was wanting to move forward with a change of circumstances petition. He and I discussed, we put in there that, yes, she was wanting to move to Louisiana, but there's also some mental health issues or some abuse issues or some other things that go along with this petition. It's not just the relocation. The mother, through Ms. Roberts, filed her answer and her counter petition on May 22nd of this year, 2026. I would bring to the court's attention the 30 days to even answer the counter petition at this point has not been exhausted. The father has had no opportunity to conduct any written discovery, take any depositions, otherwise develop the evidentiary record necessary to respond to the mother's relocation claim that she's wanting to take up today. The mother's relocation was filed about June 3rd, 2026, and again was set for a hearing 13 days later on today's date, June 16th of 2026. It was more or less than 2 weeks after the filing. If we look at the Parental Relocation Act, this codified TCA 36-6-108, it goes on to talk about, in part, Section A says that, and again, in part, the relocating parent shall send a notice to the other parent's last known address by registered or certified mail. One of my objections is she sent a text message. We allege that in our petition. She responded and admitted to that in the counter petition. So I think that's a fact that can be, drawn out. And that's not the proper procedural way by the law to start a Parental Relocation Act. So as far as our position goes today, even short term, that the Parental Relocation Act hasn't even been invoked yet because it's not been started properly. Further, the agreement goes on, further the Parental Relocation Act in Section B provides, again, it's in part that absent agreement by the parties on a new visitation schedule, if it was to be brought about properly, within 30 days of the notice or upon a timely objection in response to the notice, The relocating parent shall file a petition seeking approval of the
Mr. Holly, is your
relocation.
client here?
He is.
You want to have him come up and have a seat at the table?
And I think that's an important part of the statute because it does say shall. It's not anything that's advisory. It says you have to.
Well, here is my concern. 366108, which is what you cited, states subsection A, after custody or co-parenting has been established by the entry of a permanent parenting plan or final order. In this case, there is no parenting plan or final order of custody that's been entered. All it is a child support, an action for child support and a complaint to establish parentage, and child support has been entered by the child support magistrate, but there's been no parenting plan entered. You filed a proposed parenting plan, but there is no parenting plan or final custody order. And the statute that you're referring to, it would require her to comply with that statute by giving notice and so forth, is not brought into effect unless there is a parenting plan or a final custody order that triggers the parental relocation statute.
May I respond?
Yes.
Well, when you say by final custody order, our position would be, when you went to child support court and she was named the primary parent, she received 85 days, pursuant to the calculation of child support, and he's been exercising a reasonable visitation. That's what the evidence will be throughout this time. There's been an order down for that. So to say that there's not been a final order, I think that was pretty well a final order. It never was appealed, and it's still sitting there. And it in part covers a lot of what a parenting plan would cover. It doesn't exactly spell out the days of visitation or talks about decision-making, granted that, but it does declare a primary residential parent. So I would say there has been a final order in this case, albeit through child support. It is sitting there. Again, and I think that the statute is pretty clear that the relocating parent shall file the petition seeking approval of the relocation. And if a petition in opposition to relocation is filed, the court shall determine, and this is C1, the court shall determine whether relocation is in the best interest of the minor child, and that's by way of an evidentiary hearing. And can you have an evidentiary hearing by motion? Yes, you can. Absolutely, you can. But at this late juncture, I can't have an evidentiary hearing today because I've not had an opportunity to gather and corroborate a lot of the evidence that's going to be before the court. I haven't, the time to file an answer to the counter petition isn't even up yet. I haven't had a chance to file interrogatories, depositions, subpoena the people down in Louisiana to talk about the job that there's a lot of suspect information that we've got coming back and forth with that. I haven't had a chance to corroborate any of that. So to try this now with 13 days of notice to say that it's okay to move, I believe she's 8 years old at this point, little girl away from the father, Judge, I don't think this was the intent of the Parental Relocation Act. I think the intent is that if you're going to have these issues, that you have these issues, you file what you need to file, and you come to court with enough time to be prepared to argue the case. And today, we have not had that amount of time, and I think the court can see that clearly just from the amount of time that since it's been filed, since we've had an opportunity to respond and take a look at this motion. Again, I think that continuing or dismissing the motion for the parental relocation at this point is appropriate. That's what I'm asking for, and for us to be able to go through the process and let the process be taken advantage of so that when we do come to court, we're not stumbling around, we're not bringing up things that may or may not be sufficient or adequate or even plausible evidence at this point. Because right now I haven't had a chance to corroborate a lot of the things that my client has said. And the Court of Appeals has expressly held that, and it's in my response, which I'm relying on, that a parent is entitled to an evidentiary hearing on a proposed relocation. Denial of such a hearing constitutes reversible error. I gave the court a case, Placencia, I believe is the way you pronounce that, versus Placencia, and that's pretty much what it stands for. That the mother in that case had a good job lined up. The father had a good job lined up in that situation, I believe it was. And they were arguing that he should be allowed to go, and they kind of, it really wasn't an evidentiary hearing, I don't think, but it was kind of a hearing in court in a time frame I think was a little more advantageous than this one, actually. And they came back and said that the mother should have been allowed an evidentiary hearing on the father's proposed relocation. And to do otherwise was reversible error. So I understand obviously the situation where mom's got a good job. At this point, we wouldn't take that as a grain of salt. We would like to have an opportunity to look at that. My client's got some hearsay-ish type responses and issues and things like that that he wants to track down and try to put this into some sort of evidence so the court will be able to make an informed decision when you do have a proper evidentiary hearing. So again, Judge, I don't think it's fair to the father at this point with 13 days to put him in that kind of position where we got to defend this today without having an opportunity to go through the process. Thank you.
Ms. Roberts?
Yes, Your Honor. Again, the cases cited by Mr. Hawley, I would point out, is prior to the 2024 modification of the rule. The parental relocation statute was modified by the legislature in 2024. So the case law that was submitted by Mr. Hawley predates that. And again, Your Honor has correctly set forth that the parental relocation statute, which is 366108, states that after custody or co-parenting has been established by entry of a permanent parenting plan or final order, if a parent who is spending intervals of time with the child desires to relocate outside the state or more than 50 miles from the other parent within the state, then the relocating parent shall send a notice to the other parent at the other parent's last known address by registered or certified mail, unless excused by the court for exigent circumstances. The notice shall be mailed not later than 60 days prior to the move. The notice shall contain the following: statement of intent to move, the purpose, the location of the proposed, and the reason. That email was sent, or text message was sent to Mr. Davis. But again, the question, number one, starting, has there been number one, there has not been a parenting plan. Contrary to the sworn petition filed by Mr. Hawley that has his signature and his client's signature, wherein they allege that a parenting plan was filed with this court, there is no parenting plan filed with this court. So their pleadings are just patently false and sworn under oath. I would make that note to the court. The only thing that happened is originally this child is a child born out of wedlock. My client sought the services of the Child Support Enforcement Agency and filed a petition seeking child support. Apparently, as you can refer to the court, Mr. Davis questioned paternity at that point in time because a DNA test was performed. And that DNA test came back with 99.99% that Mr. Davis is the father. And at that point in time, a order was filed, a finding and recommendation was filed by the then child support referee, and it was confirmed by the court, wherein Mrs. now Wingate was designated as the child, Kenley's primary residential parent. Mr. Davis was designated as the alternate residential parent. And the statute said that she was given custody and he was giving reasonable visitation. There is no specific parenting plan. There's no recitation of the parental rights in the state of Tennessee that's contained in that order. Those findings and recommendations that were later found in an order. After that, there was a petition to modify the child support, and there was a finding of a 15% variance in the child support guidelines, and child support was increased, and then the recitation again that now Mrs. Wingate, the mother, was designated as the primary residential parent, Mr. Davis was the alternate residential parent, and that he had just reasonable visitation. The numbers reflected in the child support worksheets that were attached to the findings and recommendation was again 285 and 85 with the father. At no time did the father come in to, or the mother, either parent come in to seek to clarify or ask for any adoption of a parenting plan. My client, not even being provided the statutory requirements set forth that would have been in a parenting plan, sent a text message. Again, the court, you can talk about strict adherence to statutory obligations, but again, anybody with a modicum of common sense would understand that registered or certified mail is necessary so that the individual had actual notice of the relocation, especially with the process of the United States mail today. And certainly probably in 2024, the legislature should have maybe modified that by email and some other scenario where you can get notice. But again, registered and certified mail is so to ensure that the court knows that the parent who is non-relocating actually had service. In this case, Your Honor, where it comes back up and says, unless excused by the court for exigent circumstances, the notice will be mailed no later than 60 days. By their pleadings in and of themselves, Mr. Davis admits that he received notice. And that's the threshold of the statute, is that he received notice of the relocation. Prior to Mrs. Wingate being able to even file, he filed. And his petition was not in the form of an objection. He filed stating that there had been a significant material change in circumstances, seeking to have a designation of the primary residential parent change, which Your Honor is aware is a higher threshold than just having a residential schedule done. And there is no residential schedule. So again, the question is, was proper notice of the relocation provided? She did not have adequate time to file a response and to file the statutory procedures because he filed prior to that, prior to giving her no time to even file something. So again, when you go on down the statute, Your Honor, he had actual notice stating, finding that it was not sent by registered or certified mail. Again, seems like an AI type of argument to make. But again, he had actual notice. And again, you have every right to file to ask for the move, and the court can consider it under exigent circumstances. My client, as set forth, has a new job. She's married, she has a new job, and she has parents in the area. And so again, that's the basis of her request to move so that she can start her job. It's during the summer. And again, there is no parenting plan. And so long as my client affords this, there's nothing to contempt her on if he doesn't have visitation. So coming in and saying that you don't want a temporary parenting plan is proverbial cutting your nose off to spite your face under a court order. The court could consider, if my client just went down there and started her job and said, look, you're not going to visit with the child, there's nothing to contempt her on. Of course, it would be one of the factors that the court can consider in a modification, but there's no statute, there's no court order stating when this man gets to see the child or when he doesn't get to see the child. And so long as she somehow complies with the 85 days, then again, there's nothing to say that that's not in compliance with the existing final order. In the manifest interest of this minor child, the best interest, she has complied with the notice requirement. He has had actual notice of the relocation. And again, the relocation doesn't have anything to do with his modification. It may, but right now it doesn't. He's just simply filed to modify based on a significant material change in circumstances, one of which, with a liberal reading of his complaint, states that Louisiana is a high crime area, which is laughable considering the circumstances by the United States Department of Justice, with the difference in the statutory, or the findings of the crime rate in the state of Tennessee and the crime rate of the state of Louisiana. I strongly suggest that they look that up, because again, there's a significant difference. And again, what is laughable in the petition is saying that the schools in Louisiana are deficient, when Tennessee rates next to last in education of its students. And Louisiana isn't behind it, Mississippi is. So again, the only positions that they have filed in their petition to modify is crime rate and education, both of which the state of Louisiana is better than the state of Tennessee. Again, this man had every right to come in and establish a parenting plan. He did not. We're here on a motion to adopt a temporary parenting schedule, which is in his best interest, and we've given notice and we're asking to relocate, which can be by motion.
Well, this court's interpretation of 366108 is that that statute, which requires the notice of parental relocation, envisions that there be a custody order down that sets out the visitation rights or that establishes a parenting plan, because it says after custody or co-parenting has been established by the entry of a permanent parenting plan or final order. We don't have anything other than the child support order in this case, which does make a finding that she's the primary residential parent and he's the alternate residential parent, and you would have reasonable visitation. But there's no limitation on her relocation. There's no indication that as to what his visitation would be, and therefore there's no ability for this court to determine that her moving to Louisiana would deprive him of reasonable visitation. That will be for a hearing, and Mr. Hawley has filed a petition that sets out that there is a material change of circumstances to change the primary residential parent, and that would be something that the court would then have to determine. So I'm of the opinion that there was not, that the parental relocation statute requiring the notice was not implicated by the juvenile court or the child support order, and so rule. And as a result of that, the question of whether or not she gave proper notice of relocation is moot, because I find that it was not required. The question of whether the court should or should not allow the relocation and, you know, the custody, whether that constitutes a change of circumstances sufficient for a change of custody, will be a factor that the court will consider on your modification request. In the interim period, this court is of the opinion that she is free to move if she wishes to do so, but then you lawyers can either come to an agreement on some sort of a visitation schedule pending the modification hearing, or we can have a hearing on that issue. So,
Your Honor, based on that, we would strike our motion for a temporary parenting.
May I address the court?
you may.
Oh, Judge, would you consider staying that? Before we talk to my client about it, I think we're going to make an application for an interlocutory Rule 10 appeal. If this was the order for today, would the court consider staying your whatever ruling we've got here?
I'm not going to stay it, but
I
I don't have a problem with the interlocutory appeal if you wish to seek one, but I am not going to stay my ruling, because I think it clearly is indicated that I'm of the opinion that this statute says when you have an order that establishes a co-parenting or a permanent parenting plan, then that's when it's triggered in. All you have is a custody, or rather a child support order, which by the child support magistrate, without any hearing on the, you know, the beneficial factors of the statute, you know, all it simply says is that he has reasonable visitation. So if you wish to seek an interlocutory appeal, I'm glad to grant you that request if you want to. But I'm not going to stay the order, the finding that I've made. So.
Okay. All right. Thank you, Judge.
So the question then becomes, since Ms. Roberts has stricken her motion to adopt a parenting plan, we are still under the reasonable visitation aspect. And Mr. Holly, if you wish to revisit that issue, you may file your own motion for adoption of a specific visitation plan. I would hope that you all can work something out till we come back.
May I address the court one other item? With the court, and I know the next thing I got to talk to him about, and I want to make sure that I'm not wasting his time or money, either one. You know, because she's going to move the next week or two. I mean, that's just where we're going here. Would the court entertain a temporary restraining order prohibiting her moving if we were to file something like that based on our petition and the fact that we do have a final order out of child support court?
You can file a petition or a motion for a temporary restraining order. From what I have read in the file as your allegations and heard in argument, I do not find that there would be a basis. A restraining order is for an extraordinary remedy that would be for irreversible harm or injury. And, you know, I'm of the opinion what the better practice would be to have some sort of temporary visitation schedule set up to allow this child to visit with both parents while she resides in Louisiana pending your modification.
Yes.
And I would instruct that the lawyers should sit down and try to come up with some sort of a plan, and then that the court will grant you a date in July if you're not able to.
And again, Judge, I would respectfully, we already moved by the time we do that, and to have a child down there and acclimated with school and all those things, it would be very difficult to bring the child back at some other future date. So that's why I'm saying there would be some exigent circumstances here, because to relocate once is one time, to relocate back from Louisiana to Tennessee, that would just put an undue hardship on that child.
I understand. However, this court is of the opinion that I cannot rule on something that's not been filed. And as a result, I've ruled on what was filed, which was the request or your objection to the notice. And I have found that the notice wasn't statutorily required because there was no parenting plan that set forth specific visitation or scheduling. So.
Yes. All right. Thank you, Judge.
All right. Then that will conclude this matter. Mr. Hawley, I've given out a couple of dates in July. If in fact you wish to file something regarding temporary visitation schedule pending the hearing on your modification.
Yes, Your Honor, thank you.
Could the court maybe give us those dates again in July?
Certainly.
July 29th.
July 29th, and I can give you July 30th as well. I just need to know if you're going to utilize the 29th, because I haven't given that out for anything else.
Thank you, Your Honor. And Your Honor, could you,
Please, the court, I would utilize July 29th and at least have that date there so that I can file the motions or whatever we need to do here.
Well,
in the
we are
process of
holding court on the 29th because I've set that Thomas versus Thomas matter. So.
Doing the interlocutory appeal as well. Thank you, Judge.
Go ahead. Ms. Roberts, you had the only other case.
yes, Your Honor, and if you could just give, I don't know when you're gonna take your lunch break.
Do I need you to take it now? I
I
can
would
take it now.
request, because again, this is about the sale of the house, and I was trying to get a hold of Mr. Price.
We're all waiting on it.
And so if you would just give us the lunch hour to maybe try to get that, then we
All right,
may.
why don't we just come back at 1 o'clock?
Thank you, Your Honor.
We're adjourned or recessed until 1 o'clock.
All rise.
Don't have
Right.
I'm writing this in here.
Oh.
I just put all other matters reserved after you signed it. Okay.
You go over it with my phone.
I know. Yeah.
Jennifer, do you mind if I put September the 16th on here as the 60-day mark?
Yeah, I mean, that is 60 days. I mean, I don't know how many, whether that's 61. I have to do
We'll
the
agree
January,
that
February,
it's-
31. We don't have February in there, so yeah, that,
I'll just put September 16th.
yeah.
Put a day, we're not gonna haggle over that.
Right, there's 31 days in what month and,
July.
yeah, yeah. So it would actually be 50, you know, but
Put a date on this.
I know, I'm, excuse me.
Scheduled.
Yeah.
Put an R on 4. Option 4.
Oh,
You just couldn't see it.
I can't see it with my handwriting before my vision problem was serial killer anyway, so now it's worse. I did it. We were in the Rotary Club of Dickson had a handwriting specialist come at one point in time. She was sitting here talking about, you know, the Unabomber, how they wrote and everything, and every one of the little nuances that she brought up, I'm sitting there going, shit, I got serial.
You're a serial.
Jennifer, as long as we obtain a closing date on the refi within that 30 days, so like, let's say they can't get us into close it until day 35.
Where'd Lynn go?
If she's just got to tell us in 30 days.
As long as she's secured financing in 30 days.
But it's not gonna financing as long as you get A, B, C, D, and E
No,
done in
correct.
about 90 days.
Correct. I just want to make sure we're all on the same page.
With a date with a check.
Date and a check, that's it. I like that.
Date and check.
Judge, we worked out an agreement that I've scratched out here. Basically what we're going to do, and we've got this signed, but I'd like to announce it.
All right.
This is in the Smith case. Your Honor, the parties own real property that was purchased during the marriage at 1337 Lee Brown Road. Previously, the court has ordered that it's been listed for sale, and we've kind of gone through a lot of stuff, but we've agreed that the house is going to be listed for sale. Neil Trice with Charles Woodard and Associates is going to be the agent. They are going to go and to sign a listing agreement immediately, but it will not go live until July 16th, which is 30 days. The parties are going to cooperate with any pre-listing obligations that Mr. Trice has to come take pictures, to get everything ready. Between now and July 16th, the wife will have the option to purchase the property. The conditions of her purchasing the property is she's going to have to refinance the existing debt and get a complete and absolute release of Mr. Smith's liability on the obligation and pay him $125,000 as his equity. If Mr. Trice, through Charles Wood and Associates, incurs any expense in that 30-day period, such as pictures, getting a title search, anything like that, that's going to be the sole responsibility of Mrs. Smith to settle up with Mr. Trice if she exercises her option to purchase. If she does not purchase, the house will go live on July 16th, and it will be listed for 60 days. If it does not sell, if there is not a contract on the house within 60 days, then the house will be auctioned and the parties will sign an auction agreement within 30. So again, as it said, should the wife not purchase the property, it will be listed for 60 days, and if no contract is accepted at the 60-day mark, which will be September 16th of 2026, then the property will be sold by public auction, and they will schedule the auction, have a signed auction agreement within 30 days. It's not going to be necessarily 30 days because, again, he's going to do it on weekends, and we'll do that. All other issues are reserved. Everybody has signed off on it. Mr. Smith, could we place them under oath?
Both of you raise your right hand. Let's place you under oath.
And I need to just add one
Good.
thing to this that we've already discussed, but so the court is aware and that it's of record. We agree that if she's able to refinance, we just let them know she's able to refinance and everything stops and she gets set to close. It doesn't have to close in that 30 days, but she needs to work towards that mark to get it closed.
We need a date and a check.
Yes.
Yeah.
So again, on that note, she comes up and calls tomorrow and says, I can refinance it, I've been approved. But it's going to be 90 days before I can do it. No, that's not what we're talking
Correct.
about.
That's correct.
She gets approved and we have a date and a check shortly after the 30, she's got to exercise her option and have a closing date within a reasonable time.
Absolutely. That's exactly what we anticipated. I just wanted it on the record.
So,
All right.
and so, Mr. Smith, you've heard what we've announced today, and that is your agreement. You want to accept that?
Yes, please.
Mr. Garrity Wheaton Smith, you've heard what we've said today.
Your Honor, and that's just, we're just gonna mark that if Your Honor would.
We're just going to ask you to mark this as an exhibit. Both parties and their counsel have signed off on it, so we'll mark it as.
And we will type up an order contemporary and consistent with
Having
that.
placed you under oath and having you acknowledge it on the record, it now becomes an order of this court, which I adopt. That means even though there's no formal written order other than this memorandum, it still is an enforceable order of the court, so make sure you comply with it.
Yes.
I'm glad you were able to get it worked out.
So y'all leave here and go to Mr. Wood's office. Go to
We
Mr.
put
Trice's
it in
office.
that agreement, but all other matters are reserved pending
Right.
final.
All right.
So Mr. Trice you need to make your way to Mr. Trice's office to sign an agreement.
He is out in the field right now, Jennifer.
That's what you need to go and schedule a time for you to go sign. Both of y'all go schedule a time for him to go
He
sign.
said he was doing,
Right,
y'all just schedule.
right, okay. Stop by
All
his
right.
office and get a time to sign.
That concludes our business for today then, and we will, is there anything else?
No, after you conclude, I have a question.